Folks, if you are convicted of a felony here in the state of Florida, and I mean anything, driving while license suspended with 2 priors, your third driving without a license will get you a felony. And guess what? It comes with a side of a lifetime ban on the possession of firearms. Every felony conviction in Florida comes with a lifetime ban on the possession of a firearm. It even makes it another felony to possess a firearm. Now, we have this thing called the Second Amendment. And the Second Amendment says that we, the people, have the right to bear arms. Felons are people too, right? And the law has to navigate who are the people that get this right to bear arms. A recent case, the United States versus Duarte, really tried to sort that out. And I'm telling you, maybe the tide is turning. The reason the tide is turning is because of a recent Supreme Court case, United States Supreme Court case of Bruen. And Bruen, I'm telling you, threw out all the Second Amendment firearm analysis that you might think of. And it just went into this analysis where it says that if the government wants to limit a person's rights under the Second Amendment, the Supreme Court says you can do so by showing that there is a historical precedent for this ban or violation or suppression of the Second Amendment for certain people. This Bruen case is really throwing the government for a loop, because the government says, we want to take away the Second Amendment right of convicted felons like Duarte. Duarte was convicted of vandalism, a nonviolent crime. And then when he got caught with a gun in his car, years later, they found him guilty of the felony of possession of a firearm by a convicted felon, and he got 51 months prison for possessing a firearm as a convicted felon. Duarte appealed that conviction, saying, you know what? The government has no right to do a lifetime ban on my Second Amendment right to possess a firearm for this nonviolent felony, because when you look at the recent decision in Bruen says that the government can't do this unless they show you that there is historical precedent for limiting the Second Amendment in this way. Well, guess what, folks? 74-page opinion on Duarte going through history. The founding fathers, the people that wrote the Second Amendment, felons were allowed to possess firearms back then. Everybody was allowed to possess firearms back then. You didn't even see the first hint of this until after World War I, and even then it was slow. So the government has a pretty high hurdle to show this court why this lifetime ban on Duarte's possession of a firearm should still stand. And the court basically said, we're not going to let this stand. The government's burden, it says, the government must prove that their lifetime ban on firearm possession for convicted felons is consistent with this nation's historical tradition of firearm regulation. That's what Bruen says. Bruen says, is this regulation, is this lifetime ban, is anything that touches the Second Amendment? If you want to touch it and poke it and do something to it, show us that historically this is permissible. They couldn't. They really couldn't. The court in 74 pages said the founding fathers had no law limiting gun possession by anybody convicted of any crime at all. This is a later development. So Duarte, believe it or not, got his case thrown out. And let me read to you what they said, because this is progress in this Second Amendment litigation. This is a good step in the right direction. One thing they say is, look, we do not as a court base our decision on the notion that felons should not be prohibited from possessing firearms, because as a matter of policy, these laws make a great deal of sense. However, Duarte is an American citizen, and thus he is one of the people whom the Second Amendment protects. The Second Amendment's plain text and historically understood meaning, therefore, presumptively guarantee his individual right to possess a firearm for self-defense. The government failed to rebut that presumption by demonstrating that permanently depriving Duarte of this fundamental right is otherwise consistent with our nation's history. The court is basically just citing Bruen's reasoning here. Therefore, we hold that the law that prohibited his possession of a firearm violates Duarte's Second Amendment right. It is unconstitutional as applied to him. His conviction is vacated, thrown out. Have a nice day. This is progress on the Second Amendment front. This is progress for convicted felons that are nonviolent and shouldn't have a lifetime ban on possession. So we'll keep monitoring this.